Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class, and tonight we will be continuing our reading from a document titled U.S.A. Republic That No One Lives In. And we've been reading this for the last few Saturday nights, and we left off at the 14th Amendment. So the document is in chat if you guys want to download it, and you can also grab it in the show note link, which would be in Odyssey once these are posted. U.S.A. The Republic is the house that no one lives in, and we left off the 14th Amendment, so I will skip down here. So in 1868, Congress passed the 14th Amendment, which accomplished primarily two things. First, it made each individual primarily a federal citizen of the municipal corporation of the District of Columbia. Second, it combined the Senate and the House in their functions so that they're now operating for the benefit of private commercial law. Until the 14th Amendment, the House functioned for private commercial benefit, and the Senate functioned for non-commercial public municipal law benefit, the benefit of the individual under Republican law. Third, it made each person responsible for the public debt by making them beneficiaries of the public trust the 14th Amendment established. The 14th Amendment was also private, non-positive law because it was enacted to set up a voluntary trust relationship that any citizen of the states could participate in if desired. Thus, the amendment was instrumental in shifting citizenship from being primarily a state citizen to being a citizen of the private corporation of government. However, this amendment was a sleeper, so to speak. That is, it could still only exercise jurisdiction of those who have chose voluntarily to participate. Interestingly, Congress knew that it was making an amendment that was based on private non-positive law and was therefore conditional. That is, the people had to have choice whether they wanted to participate or not in what the 14th Amendment was offering. Otherwise, it would have been totally and completely unconstitutional. Therefore, one day before the 14th Amendment was passed, Congress passed 15 Statute 249-250. This statute provided for a person to remove him or herself from the jurisdiction of the 14th Amendment trust if they so desired. So the 14th Amendment set in motion the process of taking private corporate law of a few, namely big business, and moving it into public sector to control the masses for their assumed benefit. The actual benefit was for the corporations. The assumed benefit lay with being a member of the public trust and therefore being able to receive benefits from the trust. Benefits in the form of whatever care the national government would come up with to provide for you from cradle to grave. Those benefits have come at a severe price since 1868. That price is the loss of our absolute liberty under the Constitution and the general common law. In exchange, we have only received back relative rights with assumed economic benefits. In reality, the benefits have been curses. And just to pause here, this is where the understanding of what the whole system was set up to do and finally finished in 1933 came from. And I would highly suggest that everyone watch the Luciferian New World Order Agenda Edward M. House lecture. It's on Odyssey and it's on YouTube to understand the rest of the system that they're talking about here, because it's very important to understand the word pledge. It's very important to understand these various different aspects of law. So I highly suggest that everybody watch that in connection with going through this document. Okay, to continue. When our founding fathers wrote the Constitution, it was far simpler to enumerate the few powers that were to be given to the national government than to try and list all the powers the individual citizen would keep. So it was that when the Bill of Rights, the first 10 amendments, was completed. Amendments 9 and 10 distinctly stated what powers one people would reserve. Amendment 9, quote, "The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Amendment 10, quote, "The powers not delegated to the United States by the Constitution, not prohibited by it to the states, are reserved to the states respectively or to the people." Close quote. So, and the 9th and 10th Amendment work as basically bookends at the end of the Bill of Rights because of what they just said. And there have been cases of which people have brought arguments on the 10th Amendment saying, hey, wait a second. I have the right to do that anyway. I was not exercising some privilege or grant of the use of something when I was doing XYZ. I have that right to begin with. And there's a case see if I can remember it. It was a case that we covered in the right to travel class, and it's in the right to travel folder. It's escaping me at the moment. I think it's Bond versus U.S. Bond or Boyd. I think it's Bond versus U.S. And anyway, the 10th Amendment argument was made. It went all the way to the Supreme Court, and the Supreme Court agreed. So just to remind everyone of that. Okay, to continue here. So it was that among all the powers, quote unquote, retained by the people, one of the most important was the power to contract for services or trades with another person or persons without interference from anyone, in or out of the government. See Article 1, Section 10. And not have the government interfere in any way. This is the protection of contracts clause. It basically says that there shall be no law passed abrogating the right of contract. So you can contract your rights away, but if you do not know that's what you're doing, or that was never explained to you up front, then technically there was no meeting of the minds, and the contract's void ab initio from the beginning. But this is basically what they're doing. They are corralling you into a contract that you're unaware of what the consequences are of entering into it. And it acts very much like a performance contract, which is also very much the way that the vocational science freedom status docs are written, particularly the kill warrant, where we put them under contract, basically in the form of a user and license agreement stating, if you're going to administer any part of our estate, you agree to be a trustee of that estate, and you also agree that I'm the executor of the estate and above you and can give you executive orders. And they have to post a bond for potential fiduciary malfeasance and all other kinds of things that they have to do. But it's still contractual. All I did was create a contractual nexus with them, but in a way that's positive for us instead of negative for us, and then removed ourselves from all of the contracts that we have possibly ever entered into. So anyway, to continue. So as discussed previously, contracts are also referred to as private law. This right to contract, meaning use private law, meant that two people could come to a meeting of the minds and agree between themselves for virtually anything they would both settle on, and the government could not interfere. For example, let's suppose that person A has developed a skill through special professional education or on-the-job training. As a non-14th Amendment citizen, he or she has the liberty to offer their services for sale without the interference of civil licensing authority, meaning go get a driver's license or go get a veterinarian's license. You know, they have to go through all that schooling, or to even go get permission, a building permit, right? Any sort of licensing authority. In other words, the licensing authority and their policing powers have no jurisdiction over a person who is not a citizen of the 14th Amendment Public Municipal Trust. Here is the secret of the true liberty of choice. As in medicine, for example, with this true liberty of the laws of the Republic, therapies that are only available outside the United States could be an option for each state. Remember, you are dealing with a political choice. Making your choice to function in the law of the Republic means the government cannot compel you to be regulated by private law of the democracy, which is what they created later in 1871 was the D.C. Municipal Act, I believe, but don't hold me to that. It was the early 1870s. I just can't remember exactly the date. Maybe somebody in chat wants to throw it in there for me to remind me. Okay, to continue. Yet there is only one very important facet of the power to contract or use private law under the Constitution. That is, if contract private laws come into dispute in the courts, the contract will be ruled on outside the Constitution. That's why all these judges, whenever you start bringing up the Constitution in these private for-profit courts that are not courts of record, they'll tell you flat out. The judges will even sometimes they'll yell at you and say the Constitution doesn't have any say in this court, and people have been taken aback by that. But the judge is absolutely 100% right. You are in a court of equity dealing with contract matters. It has nothing to do with the Constitution. You got a driver's license, you registered your car, and so the presumption is that you're engaged in commerce. And if you're engaged in commerce, well, then the government can regulate you. Or say, for example, from a mortgage contract, right? There's all these various different things in the mortgage contract, and when you sign it, you give them power of attorney and all kinds of other powers over you that you didn't even know were in there, unless you diligently read it line by line. And so the judge is just saying, look, all we're doing is upholding contract law here. That's all they're doing. It has nothing to do with the Constitution. So just be aware of that. Okay, to continue. You read correctly. Contracts or private agreements will always overrule the Constitution and the Bill of Rights. In other words, specific private agreements, called contracts, governing individual circumstances between two or more persons will always overrule broad general clauses found in the Constitution. This is because it is illogical to allow someone to take a clause out of the Constitution that was not part of their original agreement and use it to weasel, twist, and squirm his way out of the contractual provisions while retaining the financial gain the private contract may have given him in the first place. In the words of the Supreme Court Justice Felix Frankfurter, quote, "Equity is brutal, but we are merely enforcing agreements," close quote. What he means is that when you go to court to dispute a contract or private law agreement that you had with someone else, the courts are there to enforce the contracts, as brutal as that may be, apart and separate from the Constitution. With the 14th Amendment in 1868, the stage was set for private law to be used outside the Constitution to financially enslave the masses and destroy the Republican Union. The stage was also set to move Roman civil law into operation within the boundaries of the United States of America, contrary to what our founding fathers ever intended. Note the words of concern in George Washington's farewell address to the American people. Quote, "The unity of government which constitutes you one people is a main pillar in the edifice of your real independence, the support of your tranquility at home, your peace abroad, of your safety, of your prosperity, of that very liberty which you so highly prize. It is easy to foresee that from some different causes and from different quarters, much pains will be taken, many artifices employed, to weaken in your minds the conviction of this truth. As this is the point in your political fortress against which the batteries of internal and external enemies will be most constantly and actively, though oftenly covertly and assiduously, directed, it is of infinite moment that you should properly estimate the immense value of your national union to your collective and individual happiness, that you should cherish a cordial, habitual, and immovable attachment to it, accustoming yourselves to think and speak of it of the palladium of your political safety and prosperity, watching for its preservation with jealous anxiety, discountenancing whatever may suggest even a suspicion that it can in any event be abandoned." So Washington knew that, you could abandon this whole entire thing if you're not careful. To continue, "And indignity frowning upon the first drawing of every attempt to alienate any portion of our country from the rest, or to enfeeble the sacred ties which now like together the various parts. One method of assault may be to effect in the forms of the Constitution alterations," meaning the 14th Amendment, "which will impair the energy of the system and thus to undermine what cannot be directly overthrown," close quote. So now we are seeing the results of the Constitution alterations in 1868, alterations that have covertly and insidiously removed the quote-unquote national union, known as the U.S.A, the Republic, and substituted economic slavery of compelled performance under contract. Yet the beauty of our Republic and the constitutional government our forefathers set up can be demonstrated from the way President James Madison responded to a bill that he vetoed on February 21st, 1811. It shows how forces of private religious conscience were always trying to force their private law on the public. And again, just to remind everyone that this private religious conscience, this is the cult of Rome. This is what they've been doing for thousands of years. It's what ecclesiastical jurisdiction is. And by the way, probate is an aspect of ecclesiastical jurisdiction. It's where it started. They might not ever say right now, at the current time, that probate is ecclesiastical jurisdiction, but all of the signs are still there. The judge still wears a black robe, which is a priest of El. They're still administering property and estates of infants who have been lost or abandoned. And everything is running through probate. In fact, there's even judges' handbooks which clearly state that they're running traffic court through probate. One of them's out of Georgia. But this is the point. So just remember, private religious conscience, where the judge can do whatever the hell they want to do up there, and it has nothing to do with the Constitution. Okay, so I'm going to read this quote. President James Madison, quote, "Because the bill exceeds the rightful authority to which governments are limited by the essential distinction between civil and religious functions, and violates in particular the article of the Constitution of the United States which declares that quote, Congress shall make no law respecting a religious establishment, close quote. The bill enacts into and establishes by law sundry rules and proceedings relative purely to the organization and policy of the Church Incorporated, and comprehending even the election and removal of the minister of the same, so that no charge could be made therein by the particular society, or by the general church of which it is a member, and whose authority it recognizes. This particular church, therefore, would so far be a religious establishment by law, a legal force and sanction being given to certain articles in its constitution and administration, as the injunctions and prohibitions contained in the regulations would be enforced by the penal consequences applicable to a violation of them according to the local law. Because the bill vests in the said incorporated church, would be a precedent for giving to religious societies as such a legal agency in carrying into effect a public and civil duty, close quote. Make another comment here. This is exactly what they did in England when, back in 1066, now this goes pretty far back. This goes back to William the Conqueror. And I've mentioned this before, but this is another important time here to mention it again. When William the Conqueror separated the spiritual and temporal courts, the spiritual courts he gave to his masters, the cult of Rome, so that they could have a foothold. So their religious musings could have a foothold in law itself. And that was exactly what James Madison was talking about here, and exactly what is not allowed to happen under the Constitution. But instead, they just found another way to do it, which was to get you under contract and then force you to obey the contract because you're taking the benefit. So, to continue. So it was not until the purported passage of the 14th Amendment that the continual push of private law into the public sector won out. At that point, private conscience law of the Roman Church became the national conscience by the way of the 14th Amendment Trust of the District of Columbia. Now notice this. In Wheaton's Elements of International Law, 6th edition, page 304, the existing rule as to freedom of religious worship is thus laid down. Quote, a minister resident in a foreign country is entitled to the privilege of religious worship in his own private chapel, according to the particular forms of his national faith, although it may be generally tolerated by the laws of the state where he resides. The laws of Rome do not tolerate any other form of public religious worship than such as conforms to the teaching of the Roman Catholic Church. But the right of any foreign minister at the papal court to hold religious services under his own roof and in accordance with the forms of his national or individual faith has never been questioned or interfered with. This the Russian, the Prussian, the American, and other representatives of foreign powers in Rome have always exercised, and still enjoy, unmolested, the freedom of religious worship in the several chapels connected with their respective legislations. These chapels, of course, are open to all compatriots of the different ministers desirous of joining in their religious services, close quote. So you see, what he's saying there is that everything is controlled. All the cult of Rome controls all of the religion, and they basically just tolerate everybody else that's not following what they're following. But when they want to come in and use the control of the courts to do so, that's what the founding fathers said, absolutely not, that's not happening here. We're not going to allow that here. Because they knew their history, they knew what happened in England, and they were not going to allow that conscience of some black-robed priest of El to rule over us. So scroll down a little bit here. Okay, to continue. The national faith applies to the 14th Amendment citizenship. It is a citizenship based on the unilateral charitable social security trust of conscience, religion, of the District of Columbia. Because it is based on a unilateral charitable contract, it cannot be tolerated in the laws of the state where one resides, meaning the laws of the Republic of the United States of America. The laws of the Republic and its separation of powers is not governed by the law of conscience or religion. That is, the Constitution mandates that the Republic will not recognize the establishment of a religion, the conscious beliefs of 1 or 1,000 individuals, as a basis for public law, because you can't tell someone else what they believe. That's your right. Here is the prescribed separation of power. It is governed by the public municipal law of the Constitution of the United States of America. Religious beliefs are a private matter within each person and are not intended to be enforced on anyone else in the Republic. This has been the very downfall of every civilization. Somebody wants to enforce their conscience religion upon everyone else. It's democracy, the exact cause of the American Revolution of 1776 and the mess of the nation today. The statute of charitable uses, charitable trusts, was enforced in the 13 original colonies by courts of the Star Chamber, enforcing writs of assistance, such as demands of the conscience of the IRS, and was the cause of the American Revolution. This is because the statute was based on the parliamentary democracy, which received its law based on the king's conscience, divine right of kings. The statute of charitable uses, trusts, never had any force in the United States until the forming of the 14th Amendment, to reinstitute the courts of the Star Chamber enforcing writs of assistance. Again, this is thou shalt not because I say so. For an example of the private conscience law of the church being moved into public policy, look at this. Quote, the Cathedral Church of St. Peter and St. Paul, also known as the National Cathedral, seeks to serve the entire nation as a house of prayer for all people. The concept of such a cathedral dates back to 1791, when Pierre L. Enfant specified a great church of national purposes in his plan for the city. So let's take a look at the exact text of the 14th Amendment so we can see what is taking place. So, Amendment 14, 1868, Section 1. Quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Which is why you never want to be a resident. No, because there's a huge difference between a resident and being lawfully domiciled. So when they call everybody a resident in all the state forms and you go ahead and you sign that and you agree with it, you step yourself right into the beginning of the 14th Amendment without ever knowing it. So I'm going to reread this again so this is clear. Quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof. So if you were born or naturalized but not subject to the jurisdiction thereof, are you then a citizen, a lowercase c citizen of the United States? And the answer is no, you're not. So you have to be both. Both of those things have to qualify in order for you to be a lowercase c citizen of the United States. And of the uppercase S state where they reside, not lowercase s state. So, all right, so we have that clear. So now to continue. No uppercase S state shall make or enforce any law which shall abridge the privileges or immunities of lowercase c citizens of the United States, nor shall any uppercase S state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction, again, being subject to their jurisdiction, the equal protection of the law. And the law there that they're talking about is Roman civil law. Section 2, quote, representatives shall be apportioned among the several states according to their representative numbers, according the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and lowercase c citizens of the United States, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion in which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. That's Section 2. And I could tear that all apart, but I'll just leave it for now because there's a very important U.S. code which states that it's presumed that you are a citizen of the United States. And if that presumption is not rebutted until before you reach the age of 21, then that presumption continues. And I forget, I have it saved, but I forget exactly what U.S. code it is. But the point is that this is all connected. The things that they have in the U.S. code now connect to the 14th Amendment, all to make sure that those presumptions stay in full force and effect so that you continue to be stuck as a second-class, lowercase c citizen, debt slave. Section 3, 14th Amendment. Quote, no person shall be a senator, representative in Congress, or elector of president or vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 4. The validity of the public debt of the United States, authorized by law, meaning Roman civil law, including debts incurred for payments of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. So, the validity of the public debt of the United States, comma, and then just skip down to the bottom, shall not be questioned. That's why he has it in italics, those two parts. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellions against the United States, or any claim of the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. And then finally, Section 5, I'll scroll down here. Quote, the Congress shall have power to enforce by appropriate legislation the provisions of this article, close quote. Okay, so first, let's notice the italicized part in Section 1. Two important facts are derived from this part. 1, this amendment deals with trust law. The phrase, and subject to, is language that is used for trusts, which are nothing more than private contractual arrangements. 2, Section 1 states that you are now to be firstly and primarily a citizen, lowercase c citizen of the United States, and secondly, and this should be a capital C citizen of the lower s state. That would be proper, but this is not. When you're a lower c citizen of an uppercase s state, you're still a slave. So just remember that. So I'm just going to type them into chat real quick just so this is clear for everyone. Because in the original federal constitution, you have a citizen, capital C citizen of the several states. So a capital C citizen of the several states is a de jure state citizen. So that's what you want to be, right? And then a lowercase c citizen of the United States is, I'll just say is a slave because that's what it is. So those are the two things that you have to be aware of. So make sure that if you're writing anything down in a document per se, then make sure that you are always an uppercase C citizen of a lowercase s state. That makes it de jure. If you are a lowercase c citizen of an uppercase s state or of the United States, you are a slave. So be very careful about how you write things, okay? Particularly in court documents and every single place where that's ever stated in any of the vocational science freedom status docs is all in the correct capitalization, just so you know that. Okay, so to continue here. 2, Section 1 states that you are now to be firstly and primarily a citizen of the United States and secondly a citizen of a state. While outside the 14th Amendment and under the full rights of the Constitution, it is just the opposite. Next, notice the italicized part of Section 4. According to this, the, quote, validity of the public debt and all of its facets shall not be questioned. Whether amendments to the federal Constitution have been properly ratified is usually a political question, and by the way, the 14th Amendment was technically never correctly ratified, just to make a point here, which has been spoken about and brought up in congressional hearings as late as the 60s, I believe. But anyway, to continue. A political question means that it is voluntary. The court will never question your choice, but will enforce that choice. This is why Section 4 of the 14th Amendment says the public debt shall not be questioned. When one is a beneficiary of the public debt, when you have volunteered politically for it, it is like suing yourself. It is impossible. Another U.S. Supreme Court decision also verifies that you can reject the benefits of a trust, the public debt, if you realize you are not the beneficiary. And just to pause here, I'm just going to highlight this sentence and make a point here. So it is like suing yourself is impossible. Another U.S. Supreme Court decision also verifies that you can reject the benefits of a trust, the public debt, if you realize you are not the beneficiary, which is why that's the whole point. You never want to take a benefit anyway. But with this particular line, this is why whenever you're in court, you should say, Your Honor, I waive all benefits from the public trust. Because if you're not taking the benefit, which means going to jail, he can't contractually put you into any situation. He can't make you pay a fine. He can't make you go to jail. Nothing. Another thing I've seen people do is that at sentencing, they'll say, Your Honor, they'll say, I sentence you to whatever, right? To such and such fine or 30 days in jail, whatever. You can say, Your Honor, I respectively decline your offer of contract. And if he gets pissed and says it again, you just say it again. Your Honor, I respectfully decline that offer of contract. You can say your or that, doesn't really matter. But you just keep saying it because everything that they're doing in these private for-profit courts is contractual, which includes verbal contracts. So if you're going to start agreeing to these verbal contracts, you're going to get stuck. So never accept anything from the public trust. And I always also make sure to state that I'm the sole lawful heir and executor of whatever the hell the name is of the defendant. Whether it's first, middle, initial, last, whether it's first, middle, last, or whether it's last, first, middle. However they have it written on the court docket, that's how I say it. Say, Your Honor, I'm the sole lawful heir and executor of John Henry Doe. Is there any objection to what I just stated? You have to put them into a position where they cannot take you into Roman civil law at all. Because any trust that they create under Roman civil law has to have some sort of res in it. Res being a thing. So if you take the res from the estate first, so the estate has to exist first, you take the res out of it, and then you chop it all up and you put it into some little trust here and a little trust there, which is what all court cases are. They're constructive trusts. So if you claim the estate from the beginning, every single trust that ever took a res from that estate is now subject to your will. Because that's how trust law works. So, anyway, just wanted to make that point, and so I'll continue here. So, in other words, it is your will to be a part of the economic benefit of the legislature. If not, then what evidence do you have to show that you have declined to be a beneficiary? This is where your Declaration of Independence comes in. Now, he does have, I think this later on in this document, he does have like an example, but all of this, everything that he's talking about regarding this stuff is all taken care of in the Vocational Science and Freedom Status Docs. It's just done in a slightly different way. The 14th Amendment is private unilateral contract law being used in the public sector to dictate public policy. Everyone born since 1868 has, by accident of birth, become subject to the 14th Amendment. Subject to, quote unquote, is accomplished through the constructive trust created under the Roman civil law offer of acceptance principles and all its ramifications, including being citizens primarily of the United States government and not of the state, lowercase s state, notice that, in which you live. Plus, you also have the additional benefit of being part of and responsible for the public debt of the trust. The 14th Amendment does not say that all persons are subject to, it says, and subject to, which is the first clue to revealing that each citizen does have a choice as to whether or not they want to be, quote unquote, subject to anything. The 14th Amendment citizenship is one which a citizen keeps unless he voluntarily relinquishes it, and which, once acquired, cannot be shifted, canceled, or diluted at the will of the federal government, the states, or any governmental unit. So yes, you can get rid of it. This is the very point of correcting your status. It is the integral part of it. Allegiance in this country is not due to Congress, but to the people, to whom the sovereign power is found. Quote, it was subsequently acknowledged by several members of this court that a central purpose of the Citizenship Clause was to create an independent basis of federal citizenship, and thus to overrun the doctrine of primary state citizenship. Notice that. This is directly out of a court case. And by the way, all these little numbers, if you want in the document, all you have to do is just hit Control and then click on it. Control right click, and it'll take you to their website, of which then it will show you the court case. So that specific court case was B. Zafronian versus Dean Rusk, Secretary of State, 1968, and so on and so forth. So if you ever want to check the links, go ahead and do so. This is from that case and right out of it. But notice again, lowercase s state, citizen, and actually this one, when you're talking about state citizen, see the citizens of the several states in the beginning of, well, it's not in the beginning, but it's in the federal constitution, where you'll see how it's written correctly. So anyway, I'll just leave that for now. So to continue, separation of church and state. With the 14th Amendment charitable trust, there is no separation of church and state. Imagine that. Organized religion today is in bed with government, and they are one flesh with it. A majority of public interests of churches today centers on the social issues of government is developing policy over, while the churches are oblivious to the fact that the government is operating as a charitable church trust. That is, government is nothing more than a political church trust for charitable purposes. The reader must understand that what a man believes in his conscience is his religion. Another way to put that, it's also your will, which is what they're stealing from you. It matters not whether he or she belongs to an organized denomination. It does not even matter if they believe in one God, 50 gods, or no God. Their personal belief is their conscience and religion. The conscience or belief of a man is changeable. It is conditioned according to whether he or she was born, raised, and educated. Conscience is being influenced every day by what one encounters. Therefore, the conscience is not absolute, but rather abstract. What one man would decide regarding some incident or happening may not be the same as what another would decide. The First Amendment of the Constitution was for the purpose of preventing religion from becoming government policy, which is exactly what it is now. Amendment 1, 1791. Congress shall make no law representing an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. That's your First Amendment. How do we petition the government for redress of grievances? You get 25 sovereigns together and you create a grand jury and you go over the top of government. You control and are above government when a grand jury of 25 members of the peerage is formed. Period. Full stop. Is anybody doing that? Not that I know of. Anyway, to continue. However, this amendment has been misunderstood according to the court cases that have dealt with it. What the First Amendment is about, literally, is to prevent an individual's personal religious conscience from being legislated into law as public policy, which is exactly what 14th Amendment is. The First Amendment said the government was not to interfere with one's rights to express his conscience by making any public policy based on it. The term religion in this amendment refers exclusively to a person's views of his relations to his Creator, though often confused with some particular form of worship from which it must be distinguished. Actually, I'll go take a look at this court case and see what that's from too. Might as well, since we have the links in front of us. And that was David versus Beeson, 133 U.S. 333. Doesn't give a date, but anyway. Okay, so that's that. Because of its abstractions and changeableness, religion has no place in the law. Right, because it's whatever the hell, it's conscience. And to make a point here, because he keeps going on and bringing up the word conscience, it's also important to understand that the aspect of courts, particularly the chancery courts, when they were invented, if you will, or created in England, what chancery was, literally, what the attorneys did is they went to the king and they said, hey, king, you seem really busy with your king's bench, which of course is common law. Why don't you create a separate jurisdiction for us? We can call it chancery, and we will, and this is not a joke, this is how this works. We will hold your conscience, meaning a black-robed priest of El gets up as a chancellor and literally pretends to hold the conscience of the king. That's chancery, everyone. And that's how it works. So just to make a point here, to understand what chancery law is, that is what it is. It's the conscience of a black-robed priest. But because here, there is no king, right? Right? There's no king to actually mirror his conscience. No. And if we've all wrapped ourselves up into the stupid democracy and we are no longer seen as sovereign, there is no sovereignty to take the conscience from. So, that filthy black-robed priest of El can do whatever the fuck he wants to up there. Literally. He can decide how much of a bad boy you've been, and he can decide to punish you, whatever accordingly, as long as he doesn't go beyond statutory limits under Roman civil law. That's basically his only limit. But other than that, yeah, do whatever he wants to. So, just be aware that that's what chancery is, okay? All right, to continue. Because of its abstractness and changeableness, religion has no place in law. The law deals only with absolutes. Law is based on the unchangeable, just as the laws of the universe express themselves through unchangeable principles. movements of the earth around the sun, the seasons of the year, etc. Law is man's right to be free to follow his dictates of his own conscience without harm or interference to himself or others. This is the main point. You can do whatever you want as long as you do not cause damage, harm, loss, or injury to someone else. And whatever that something is, then that by definition is a right. Do say, well, what's the definition of right? It's anything you want to do that does not cause damage, harm, loss, or injury to someone else or their property. That is a right. In contrast to that, to continue here, Roman civil law, as discussed earlier, is the opposite. It dictates what the conscience of an individual should be obligated to by the way of the civil government's codes and law, meaning statutes, acts, ordinances, and codes. This is what they are. Statutes, acts, ordinances, and codes are filthy Roman civil law, and they were never meant to have any power over us whatsoever. And if there's any question about that, all you got to do is just read the title of Bouvier's Law Dictionary, which in case anybody doesn't know what that is, I'll just bring it up right now. It's in my law reference section. So the title of Bouvier's Law Dictionary is as follows. And I'll put it in the chat too, just so everybody gets the point here and can read it, in case you're not watching the stream here. So the title of Bouvier's Law Dictionary is as follows. A law dictionary adapted to the Constitution and laws of the United States of America, right? And of the several states of the American Union, with references to the civil, meaning Roman civil law, because whenever you see the word civil law, it's always, always, always Roman civil law, with references to the civil and other systems of foreign law. Roman civil law is fucking foreign to you, always will be. That's the point, at least in the Republic. But when they drag you into the democracy, you are completely 100% subject to Roman civil law, and you have zero protection from the common law. That is what the attorneys did. That's what they've done in multiple different countries. It's what they did in England, and it's what they've accomplished here, because no one was paying any attention to what they were doing. So this is the difference. This is what it is. You've got this private conscience of the filth of Rome coming in here and dictating to you how you should act, what you should do, what you can put in your body, who you can have sex with, who you can marry, right? Or even so much as the very right of locomotion, traveling from one place to another. No, you have to get a license for that. Huh? I'm just traveling. No, you're driving. No, I'm traveling. Well, no, you have to be driving, because then if you're not driving, then we don't have any jurisdiction over you. So you're driving. Right? This is the problem. These kind of arguments. They have to bind you into some sort of contractual nexus in order for any of their filthy Roman civil law to apply to you. It's all contractual. Every single bit of it. And when people realize that, and they stop contracting with the corporate state, and they remove themselves from all contracts with the corporate state, and they tell them to fuck off, and they correct their status and say, nope, I'm not a 14th Amendment citizen of the United States, then the status is corrected. Then, as long as you don't go back in there and start contracting with them again, meaning, Daddy, can I please have a benefit from such and such or whatever, as long as you don't go back under contract, you're out. And the first thing that I always say to a filthy Roman civil law pig is, I don't have any contracts with the corporate state. What is your business with me? And that usually throws them for a big, big loop. Because most of them, if they have any half brains at all, or they've been in the service of the Khazarian mob for a while, they know that everything's contractual. And so what they'll do is they'll go get their sergeant, and then the sergeant will come, and he'll ask you a bunch of questions like, do you have a bank account? No. Do you have a social security number? No. So you don't have any contracts? No, I don't have a social security number. Again, as I asked him, I'll ask you. I don't have any contracts with the corporate state. What is your business with me? And pretty much every time they'll just fuck off right there, because they don't have a contract. Don't have it. Now, if you're traveling around in their property that at some point in time had been registered in the past, even if you weren't the one that registered it, well, then there's a contractual nexus there. Somewhere or another, there was a contract dealing with that property. That property changed hands from one infant to another, of which they, exchanged monopoly money, called Federal Reserve notes, that didn't mean anything. And so therefore, the title never transferred because the title is sitting at the Secretary of State's office in whatever state that car was bought in. Sitting in the Secretary of State's office of whatever license the person bought the car with. Yeah, that's correct. And so the cop knows that. So if he says, license and registration, you don't have a license, but you can convince him that you're traveling, not driving. But the lack of registration, if you don't have it, but he knows that it's been registered, because all he has to do is look up the VIN number, well, then you're wandering around using a piece of property that doesn't belong to you, that you do not have the title for. Meaning the actual title is the MCO, meaning Manufacturer's Certificate of Origin. That is the title to the car. You don't have it. You are an infant playing in the commercial sandbox under the presumption, or it is a presumption, that you are operating in commerce on the roads and highways. So they can contractually bring you in by presumption. So, anyway, I'll get off my soapbox. To continue here. So since the 14th Amendment, religious conscience has been allowed to become public policy. That is, contrary to the First Amendment, a man or a few men's religious ideas are now consistently becoming or changing public policy because of the formation of the Public Charitable Trust, Church Trust, of the 14th Amendment operating outside the confines of the Constitution. Any organization that is incorporated with a nonprofit status will fall into the category of a church and is involved in public policy of the 14th Amendment Church. They are benefiting as a beneficiary of the trust. This means that all income received from the trust, because of the privilege of existing in the abstract nonprofit corporate status. Parallel to this, all profit corporations are churches, as well because of their relationship with the 14th Amendment Trust. Under the 14th Amendment, individual persons, meaning infants, are put on the same level as corporations, also called persons. The state becomes a conscience of every member of its charitable trust, and the conscience of the trust is the one who has the greatest amount of influence or money. This is a problem with democracy. Vis-a-vis special interest groups to sway versus lobby legislators, meaning AIPAC and all the rest of the filthy Israel lobby. If you are involved in trying to influence and shape legislative law, abortion, gun control, vitamin supplements, etc., you are involved in special interest attempting to dictate public policy by way of private religious conscience known as the 14th Amendment Charitable Trust of the United States, the federal government. Nonprofit groups, small or large, are dead to the law of the Republic. In other words, the person is considered an artificial creation of the state or a reincarnated group of legally dead people acting as one corporate person. The jurisdiction in which these persons exist is a religious jurisdiction. The only courts that persons of the 14th Amendment have access are legislative courts, also called ecclesiastical courts. Right? Remember what I said about ecclesiastical courts? Because they operate in a papal fashion, dictating the conscience of the church. Pope, 14th Amendment Charitable Trust as law. This is the reason why judges have to follow what's called judicial canon. You know of anything else that has canons? That's right. Think about it. And you should go look up what those canons are that they have to follow. Because if you put a judge on the spot and corner him and force him and demand that he obey judicial canon and he doesn't, the Jesuits will take him out. I got a whole story about that, but I won't get into it. I'm just going to make a point that it's deadly serious. Okay? Their judicial canons are deadly serious to their masters because they cannot break them because they're all operating in ecclesiastical courts. So one of the fun things to do is to stick the judge in the box of at least the canons, because some of those canons are actually helpful. But anyway, I won't get into that tonight. That's a whole other class. So take a look at the word diocese, disease, decado. These words demonstrate the jurisdiction, the state of existence, and the movement of persons in the 14th Amendment Church Trust. Diocese. Housekeeping. Province, diocese, derivative of dia through odicon, to manage a household. Province is also the district over which the jurisdiction of an archbishop extends. Hence, provisional courts, the ecclesiastical courts of the two archbishops. A territorial division or colony of a country. Duty, power, responsibility. Thus, it is the province of the court to judge the law, that of the jury to decide the facts. That's what you have going on in ecclesiastical courts. And I'm going to make a very important point here regarding what they're saying here about juries, that the jury is to decide the facts. The jury decides the facts only if you're if you're not asking for a general verdict. If you ask for a general verdict in a court of record and demand a jury, the jury gets to decide both the facts and the law because they're sovereign. Only in inferior courts do you have juries only deciding the facts and judges deciding the law. In a proper jury nullification is the power to nullify the law. That's what it is. And the reason why it never happens is because no one is running courts of record and then demanding to have a general verdict from the jury. Now, I think it would be fascinating to do that as the plaintiff and be like, look, I'm the plaintiff. I'm suing you. Or as a counterplaintiff, you're suing the state because they did something stupid. Whatever, doesn't matter. You open your court of record and you demand to have a jury of the peerage, but also demand in your paperwork that they render a general verdict. That way you give complete power to that jury, but also every single one on that jury has to be a sovereign, meaning they cannot be a citizen of the United States. So what are you going to get rid of? You're going to get rid of every single communist moron that they would ever try and put up there. And only people who are sovereign, only people who know who the fuck they are would be able to be on that jury. And I can guarantee you that jury is never going to find you guilty under Roman civil law. But anyway, these are the types of things that you can do. These are all things that are possible under our proper Republic jurisprudence, just that no one ever bothers to learn them. Okay, to continue. Province in ecclesiastical geography usually denotes that union of several dioceses which constitutes an archbishopric, I guess. It is often counterminous, I don't know how to pronounce that, with several states, with an entire country, or with several countries. So, diocese, to withdraw. Then this is the other one. Dissentio, or descendant, to move down duly, withdraw, retire, clear out, with the idea of making way for another. To retire in favor of another, to give up rights, possessions, etc. To give place, yield. Of living beings, to depart from life. To die, to dies. Things, to abate. Subside, cease, to go away. Go wrong, depart, swerve, transfer. Duty, faith, etc. Right? This is the decedent. They call you a decedent in your IRS master file. Did you know that? You'd better, because that's how they're keeping track of you. They're keeping accounting of abandoned infants' estates who they presume are dead. That's all they're doing. The IRS is nothing but a glorified accounting firm. And they're all running it through ecclesiastical jurisdiction. Completely. And I'm going to click on this link because I am curious if this is actually from a court case or if this is out of a dictionary. Okay, it says Ibid. Oh, Latin dictionary. Gotcha. Okay, so he took that out of Latin dictionary. It's logical. All right, good stuff. Somebody asked, just as a side note, somebody asked me the other day, is there any books that you learn to read Latin? And I said, no, once you just keep reading Latin over and over and over, strangely enough, there comes a point where you can just kind of understand it. At least that's what had happened to me. And of course, Google Translate helps, obviously. And having a Latin dictionary also helps. But just reading Latin is a good exercise in language anyway, because a lot of the roots of a lot of words obviously come from Latin, and it's important to understand the etymology. For example, the etymology of the word government. Okay, let's get to expatriation and then I'll stop. Okay, so because an individual is dead and departed from the light of life of the law, given up his or her own conscience for another's, vis-a-vis the trust, they have descended down from being an absolute sovereign into a lesser law of servitude to the conscience authority of a territory overseen totally by policy dictated by the conscience of a few controlling the masses for their assumed best good. The person is considered an incompetent under the 14th Amendment. I'll read that again. The person is considered an incompetent under the 14th Amendment. That is, you are incapable of managing your own affairs and have agreed to all of this by your silence. A silence of ignorance. Silence on your part is assumed as acceptance of the economic benefits you were offered at birth by the operation of the 14th Amendment trust. So you see how this one last paragraph fits everything together. Everything I've ever spoken about, everything that I've told what the status docs reverse, meaning the presumption of death, the presumption of infancy, and the presumption of incompetency. All of this is what they are doing. And it's clear as day once you finally see the light. But if you're stuck in the darkness and you've never learned law, God help you of trying to get out of this system, because you have no idea what's going on. So with that, I'll mark expatriation here for when we can come back to next Saturday, and I'll go get rid of the mark up top. So if anybody has any comments or questions, you can feel free to post them in the chat. I'll double check chat to make sure that there weren't any that I missed. Also, we have to go find that 15 statute here, and we have to do it. So therefore, one day before the 14th Amendment. So I gotta grab this. I think what 15 statute 249-250 is I think it's the Expatriation Act. So yeah, I'll double check that it is that if it's not the Expatriation Act, but I'm pretty sure it is. Because what they did was they gave everybody an out. So I'll make sure that I have this document for next time where we start off, and I will just make sure to bring it up and read it. Because if it is the Expatriation Act, that would make perfect sense that he's bringing it up there, and that people should go read it, because it is your way out. Because they give you a way out just the way that they gave you a way in. Because if they didn't, it wouldn't be your choice anymore, would it? It would actually be slavery. And that is unlawful. So, or wait, somebody just posted some chat. Okay, after posting the status doc set, would something like a VA disability benefit consume some sort of exceptions to the Constitution, or some of the continuation of the conditions of the contract? Okay, Janice, if you're getting benefits from an aspect of a VA, that's a contractual thing, right? So what you could do, here's the point. If you do not specifically go and get rid of that contract and say, hey, you know what? I don't want this contract anymore, they're going to continue the contract to pay you out of whatever the contract says. They're not just going to, say, nope, you're out of here, or you don't get it. Because even if you correct your status under the 14th Amendment, you say, look, I'm not a citizen of the United States. I'm a de jure state citizen, so on and so forth. That contract that they have to pay you for is still in full force and effect. But your status itself would be changed. So that would be how it works. And then Tug put in something from possible loss of, I think I've read this before. I think I've gone to this site before and looked at this, but I'll double check real quick. State travel advice about possible loss of U.S. nationality and dual nationality. Yeah, I've read this before. So this is the kind of things that they'll warn you about when you go to the consulate office and say, I feel like today relinquishing my United States citizenship. And they'll go, well, do you understand what that means? And they say, yes, I do. But this is some of the stuff that they'll ramble off to you. And yeah, these are some of the things you can do, but just formally renouncing U.S. nationality before a U.S. diplomatic consular officer inside the United States instead of outside is the way that most people have done it. So, just to make a point about that. Then is there anything else anybody put in chat? Bodhisattva, has anyone acquired their IRS master file yet? I have not gotten mine yet. I have all of the documentation for it and how to do it. If you want, all you have to do, if you want the documentation and stuff, all you got to do is go over to the group, the VSOF committee groups, which is underneath the VSOF symbol in the far upper left-hand corner of the server. So go down to VSOF committee groups and then go down, and I think I've got, so it's under the forums for IRS, for the IRS committee room on how to get your master file. There's a forum for it. So it says IRS master file information. That's where I would start to look for it. And yeah, anybody can do this. So if we want to get into more information, if anybody wants to help or get their IRS master file, make sure that you talk about this in the IRS committee room so that we can keep all this information in one place and so that everybody else can learn from what everybody else finds. Okay, so that's that. One more thing. It talks about being stateless puts us under the authority of government. No, it doesn't, because you're not stateless. Your nation, you got to remember that each individual states are the nations. The individual states are nations. Always have been. That's why they have governors. The United States of America is a trust. That's why it has a president. So you're not stateless. They might not like it, what you're doing, but they cannot consider, no way can they consider you to be stateless. I mean, the certificate of live birth itself would rebut any presumption that you're stateless. So don't worry about that. And would the oath to the Constitution also be considered some sort of continuation of the 14th Amendment? No, because the oath to uphold and protect the Constitution of the United States of America existed long before the 14th Amendment ever existed. So I would say no. Now, if they changed the oath in some way, shape, or form where it said that you uphold and protect the Constitution of the United States and didn't say the Constitution for the United States of America, well, yeah, then I would probably see that it would be an aspect of kind of getting stuck under the 14th in some weird way. So, you think it has been changed? Yeah, it would surprise me if it has. And my guess is that it probably did get changed to the Constitution of the United States, which is basically everything after the original 13th Amendment. Because the original 13th Amendment was not freeing the slaves, by the way. The original 13th Amendment was basically a restating of what was already in the Articles of Confederation, which means that you could not have allegiance to a foreign prince or principality. And if anybody wants to read what the original 13th Amendment was all about, you can go down into the archives section, and I have that under the original 13th Amendment. So there's links on information there, and you guys can go read it if that's something that you did not know about or that you want to learn more about. So looks like we're good for the night. So I'll sign off. Again, thanks everybody for coming, and I'll see you guys on Wednesday at the Open Roundtable at 7 o'clock Wednesday night. And until then, stay safe and stay sovereign.